What's up, STS Nation, and welcome to another episode of Surviving the Survivor, the podcast that promises to bring you the best guests in all of true crime. And today you're in for a treat if you are following the Alex Murdaugh trial. All eyes remain on Walterboro, South Carolina, as the double murder trial of embattled former disbarred attorney Alex Murdaugh continues into the second week. He's accused of shooting to death his wife Maggie and son Paul. On Wednesday, Alex Murdaugh sobbed in court as a chilling video was played in which three voices can be heard at the murder scene of his wife Maggie and son Paul. And that, my friends, is just a fraction of the story. You are looking at a distinguished gentleman on the left side. That is Kim R. Varner. He's been in general practice in Greenville, South Carolina since 1979, with a major emphasis in criminal defense and domestic litigation. He's been on CNN, CBS Early Show, Air America, the list goes on. His son, which I love, the fact that there's a father-son duo on here, is C. Grant Varner. Born and raised in Greenville, South Carolina. He's lived there a majority of his life. He is an attorney practicing in multiple areas, including divorce, child custody, child support, and personal injury. If you think the criminal courtroom is dangerous, you haven't been in the family courtroom. And he, too, has been on CNN, The Early Show, and many other programs. And they're actually doing analysis on this trial for their local Fox station in South Carolina. Please remember to follow us on Instagram, Facebook, Twitter. We are at Podcast STS. Also, you can listen to us anywhere you listen to podcasts. Please support us at Patreon. You can become a YouTube member. And as my 8 and 7-year-old daughter, who got mad at me that I was only saying my 8-year-old daughter, so I'll say both, say hit the subscribe button and the like button. It gets the algorithm really chugging. So, Kim, let's get right into it today. Today's court session, which just began about an hour and 20 minutes ago, began with the Judge Newman, explaining why he allowed the prosecution to ask Wednesday's final witness about Alex's financial crimes. Newman says that Murdaugh's defense team opened that door by turning Rogan Gibson into a character witness. Does Judge Newman have a point here, Kim?
I think that was a poorly asked question. It could have been more artfully crafted. I think the judge had a right to say that the door was open. It is a character case. However, the ramifications of that is this case may go another 2 or 3 weeks because there are numerous financial allegations and there's evidence of 90 other alleged criminal offenses. So we're going to be trying a lot more than a murder case from here on out.
Very interesting. Grant, to you, taking a half step back here, you were born and raised in Greenville, albeit younger than your father. Have you ever seen anything like this in the state of South Carolina? Is this the only thing people are talking about? And how are you following the case?
So in my 15 years of practice, I have not seen a case, I'm not going to say of this magnitude, but with this many moving parts. You know, the fact that it was scheduled for 3 weeks tells you from the get-go, this is going to be complex litigation. This is going to be a complex trial. Oh, and with Judge Newman opening the door for all the financial crimes evidence to come in, it certainly just added a whole nother level of complex to it. You know, when Fox Carolina asked me to be their trial analyst for this, we converted our conference room here at the office into a media center of sorts so we could live stream multiple sources. And on day 3 of the first week, I think they were wrapping up jury selection, I went in to do my trial analysis, and I told them, I said, look, this thing is massive. We haven't seen anything like this probably since the Pee Wee Gaskins case, which oddly enough involved Dick Harpootlian as well. But we need to bring in some assistance. We brought my dad into it. We have worked on the internet and the routers here at the office to try to get as much bandwidth as we can. Obviously, we've had a little technical difficulty with the rain. We're coming to you live via cell phone today instead of webcam, but we're going to make it work. And I try to have a continuous open conversation with my colleagues and peers, get their perceptions, what have they observed. Basically, as many avenues as I can get my ears to listen to. I'm trying to take in everything I can about this trial. And bear in mind, there's just so much going on here. We can't possibly keep up with all of it. There have been way too many facts introduced. I don't know how the jury is keeping up with it at this point.
Yeah, we've had a few authors on, crime writers, who say you couldn't make this up. So it goes to show that truth is often stranger than fiction. Back to you, Kim. You've been practicing since 1979, 40 some odd years. What is your 360 bird's eye view of this case to this point? And who do you feel has got the edge right now, the state or the defense?
At this stage, you're asking someone to call a football game when you're 5 minutes into the first quarter. But I think the defense is in a more powerful position at this stage. You have to consider the Constitution of the United States. A person is presumed to be innocent, and that presumption stays with them till the jury goes into the deliberation room. I'm sorry. And the burden of proof is on the state, and they must prove their case beyond any reasonable doubt. What we have so far is, number one, a father allegedly brutally and massively killed his son and his wife. That is the allegation. For reasons I don't fully understand, but the Attorney General's office, the prosecution, has presented a motive, which was to take attention away from the financial crimes allegedly committed by the defendant. What we have, and this is from the very onset, they had a shirt. SLED's expert initially said it was blood transfer. SLED had several other experts look at it who said it was blood splatter. That is significantly different. But the striking thing is, after the test was done, the shirt was destroyed. That deprived the defendant of the opportunity to have an independent examination. And if I was sitting on the jury, I'd want to know, that's a key piece of evidence. Where is it? They also did not search his home. That was obviously part of the crime scene. He stated that he went back to his home to get a gun. The allegations or inferences are he cleaned himself off because this was an execution. I mean, it had to be a mess. But nobody went in to check the drains for blood in his showers. There was no search of the home. That's left us with a critical piece of evidence missing. They have no murder weapon. That has not been located. The motive is suspect at the very least. It's leaving it open for speculation and guesswork by the jury. And on top of that, they don't actually have a time of death within a specific window. So that's a multitude of problems. But again, the state has not finished their case at this stage.
And to your point about this change of clothing, right on cue, this morning, since we are coming to you live today, the state called a Snapchat representative. Heidi Galore is her name. Her responsibilities with Snapchat include responding to search warrants, subpoenas, and other law enforcement inquiries. Now, she went on to confirm on the witness stand that a video that Paul recorded of Alex Murdaugh was published on Snapchat on June 7th, 2021, of course, the day of the murders, at 7:38 p.m. Galore said that Paul's friends could have seen his location on Snapchat if he allowed it in the app settings. But the point of that video, which is, give or take an hour and change, depending on where you put the time of death, ahead of the crimes, it shows him in a totally different set of clothing. In your opinion, Kim, does this sway the jury, or does the defense just simply say, well, he had dinner, he changed his clothes, people change their clothes?
that would certainly lean toward why did the man change his clothes? But you have to remember, this is the lower part of the state of South Carolina. It is incredibly humid. It is incredibly hot. There was testimony by one of the sled agents that she thought he had freshly changed his clothes. And the answer was, or the question was, why? She said he was sweating very much, but his clothes weren't wet. It is not unusual that people, particularly near the coast or in the lower part of this state, will change clothes because you do get wet. The humidity is incredible. The heat is rather intense. And this was in the heat of South Carolina. And that can possibly be explained. I don't believe that that's proof beyond a reasonable doubt, but obviously he had a clothes change. And there was evidence that a storm was coming. And I don't know if there's been any testimony that there was a shower earlier in the day, but he was also out on his farm. They're, working with the dogs. There's all kinds of things you do, and people do change their clothes to give him, and the law says give him the benefit of the doubt. I think that is the factor that the jury is going to look at.
Grant, to you, this is something we talked about amongst ourselves yesterday, but I'm sure the people who are going to be watching it live, and then, of course, many more watching it on tape, as they say, the prosecution doesn't need to prove motive, but their motive so far seems to be to divert from financial crimes. And that is the reason that he murdered his wife and his son. And, I think we hear it in the news quite often, so people can understand to some extent the killing of a spouse, but the killing of a son is a whole other level. And I have a son, and I know Kim has a son, and Grant, I don't know if you have children, but my point is this. Even though motive doesn't have to be proved, is this fairly weak on the part of the state to say he took his son from this earth to simply divert attention and gain empathy revolving around his financial crimes, which are there are plenty of them.
Oh, absolutely. So you're absolutely correct. You don't have to prove motive in this case, but quite typically a jury in a murder case wants to know why. There has to be a reason. If there's no reason, it's tough to secure a conviction. And the prosecution has alleged that this was to cover up the financial crimes. Not necessarily cover it up, but divert attention from it, potentially to buy himself more time. I think what you're going to see the defense bring about is, look, Maggie was of no benefit to him if she's dead. There was no life insurance on Maggie, no life insurance on Paul. And I don't believe this has been presented to the jury yet, but I anticipate probably will be at some point in the future. Back in 2016, they transferred all of their substantial assets to Maggie's name only. More than 3 years have passed, which means that it's going to be really tough if Maggie's alive to take any of these assets from the Murdaughs. It's going to be very difficult for creditors to grab it or judgment creditors to get it and claw it back to compensate victims of his crimes. With Maggie deceased, her will leaves everything to Alex. Now it's back in the clutches of the judgment creditors. So I think it's plausible to say as early as 2016, these folks had a plan. I'm not going to speculate whether they were working together or not, but I would certainly say Maggie was aware substantial assets were being put in her name, and she very likely wondered why or knew why. But with Maggie gone, that plan is completely unraveled. There's very little left he can do to protect those assets. And we're seeing that play out now in the probate court with the appointment of a receiver, because they're arguing Slayer statute. These homes and such cannot transfer to Alex Murdaugh. Now we've got to bring Buster into the mix. If there was a plan, it completely unravels. And it takes away from the motive that he may have killed them to divert attention. It just completely undermines what, and if I was the defense attorney, the plan would have been. So certainly a jury is going to question why. What was the motivation here? And I think the defense likely is going to have a lot of counterpoints to this financial crime, allegation being used to divert attention.
And so, Kim, to you now, just about 45 minutes ago, again, since we are coming to you live and it'll be available on tape, in perpetuity, but about 45 minutes ago live, Judge Newman said he wants to hold separate hearings where the lawyers can discuss without the jury if any of the financial crime evidence will be admitted. The judge dismissed the jury until further instruction at that point. But what is your hunch? Does all this financial crime evidence get admitted or not with your vast experience?
First, I don't think it's nearly as significant as everyone believes it to be. Not the allegations of the crime, but the evidence of it, because this isn't a small town. There's 38,000 people in the county. Unless somebody in that county, and that's where the case is being held, unless somebody in that county has not watched TV, not looked at the internet, not even talked to a neighbor, they already have knowledge of these 99 other accusations. I think the judge, and again, we're speculating, but I think that he is going to limit it because if they went on with 99 separate crimes, we could be here for the next year. They're not going to try those crimes. We're trying a murder case, but because the judge feels that the defense opened the door to character, I think he's going to allow some of it in, but I think he's going to put some kind of guardrails on it to limit it. But I think it will get to the jury at this stage based on Judge Newman's rulings this morning. And I think it is going to substantially lengthen the trial, and it's going to complicate the trial without any question. And I think he will put guardrails on it, and he will put some kind of confinement where he will let them go into it somewhat, but there's going to be a stopping point.
And questions are starting to flow in here. Grant, I'll toss this one to you. I know absolutely nothing about firearms. I'm a kid from suburban New Jersey. LK writes, open the door with Rogan and cement it with Will on cross. Can anyone familiar with firearms break down the scope like red beam, not legal scope, and why it was significant to be addressed? Any idea about this?
I don't recall any testimony specific to a particular scope on a rifle. The part of the trial I watched where they were introducing firearms, they essentially introduced every 12 gauge and every 300 blackout chambered rifle that they recovered from the property over the objection of the defense. I thought something that was notable there is it was made clear none of these had been identified as the potential murder weapons. And I'm still waiting to see how the prosecution brings that back around and shows relevance other than they did a pile of testing on it to exclude them as a murder weapon. I suspect based on testimony that I've heard that it's going to be argued, well, the 300 blackout rifle that was built by Alex Murdaugh's cousin is very similar to the one that is quote unquote unaccounted for. And I think they're going to have a lot of testimony about, or I think there was some testimony about how the rounds that were found ejected on the property had ejector and striker marks that were comparable to the rounds found near the bodies, or Maggie's body in particular, I think. But I didn't catch anything in particular about a scope.
Can I help you?
Did you catch that part?
Yes. This is part of what I watched. Grant didn't. When they had his friend Rogan on and the other gentleman, his other friend, they testified that the gun that the prosecution has is a red dot scope. There was testimony that they hunted previously and they had a scope, and you're more of a gun expert than me, that had it would detect body heat from the animals, and they haven't found that gun yet. So that's the distinction in the scopes, how they recognized each of the guns to identify there was at least a missing gun, which no one knows where it is. That would give me problems if I was sitting on the jury. Where's that gun? Why hasn't Alex come up with it? But again, you cannot switch the burden to the defendant under the law.
Grant, Dad's always drop pearls of wisdom. What is the singular best legal advice that your father has given you that's stuck in your head?
Oh, where do you start? That's an hours-long dissertation. I did not have a normal childhood. Our dinner table discussions were, I have this case. This is what's going on. None of you at the dinner table are attorneys. If you were sitting on a jury, what from this fact pattern would stick out to you? And as I was going through law school, there are a lot of hypotheticals, a lot of case theories thrown to you. And it was not uncommon for us to be sitting at my house in law school and wake him up at 1 or 2 in the morning and go, we're stuck. We're discussing this. Sorry to wake you at 2 a.m. What are your thoughts? And at 2 a.m., he could rattle off things that we were sitting there going, man, why couldn't we think of that from a dead sleep at 2 a.m.? But one of the most important things that he taught me was with regard to witness preparation. A lot of attorneys work at length to prep witnesses for trial, and he made it very simple. Say what you mean what you say. And if you prep a witness with that, boy, let me tell you, trial preparation is a whole lot easier, especially if your client can grasp that concept. That has been, instrumental in my success with trial work.
I could tell your dad had some sage advice, and I could tell you're a strong attorney in your own right. Legal Heartbreaker says, defense is definitely winning at this point, followed up by this comment. Kim, to you, I'm wondering, will he testify on his behalf? Dick Harpootlian. Any chance Dick lets him get up there and testify, considering that he is an attorney?
First, defense lawyers never want their client on the witness stand. Never. Because it does infer to the jury you're trying to prove something. But there's an old adage among lawyers, we can tell you how to do it, but lawyers are the world's worst witnesses. We don't do well doing it. We anticipate questions. We give you answers that are quite obviously, they're lawyers, too long, too complex. Jurors generally are not in love with lawyers. They're not going to like his approach or his analysis. And in that regard, if I was the attorney general, my first question to him, if he dared get on the witness stand, is, Mr. Murdaugh, were you on drugs at the time you did this or this allegation? Because you've already admitted you had a drug addiction problem. That's opening a monumental can of worms. I don't see it happening, and I don't believe it will happen. I don't think he will testify. And
that's what the consensus is from the experts, and you're one of them who I've talked to. Now, there's a broad overview I want to cover of Wednesday's testimony, keeping in mind that today, Thursday's testimony, is still rolling in since we're here on the East Coast before noon Eastern time. But in court yesterday, Alex Murdaugh sobbed as this chilling video was played, and you can hear 3 voices at the murder scene of his wife, Maggie and Paul. Prosecutors say that one of those voices belongs to the accused. And I believe there were 2 witnesses who came forward and said they're 100% certain that it is the voice of Alex Murdaugh. How damning is that? And let me couple that with another question to you, Kim. We don't really know the time of death. The coroner estimates it between, I think, 9:06 p.m. and 9:30 p.m., but the prosecution, the state, says it happened at 8:50. And if that is the case, and this video was shot at 8:44 p.m., and you do the math, it's 6 minutes before they were killed, putting Alec at the scene of the crime and not at supper, like he said. So if you could, just break that down a little bit for us.
I think the defense is going to handle that in this manner. There is no question, I believe at 9:06 or possibly 9:08, Alex sent a text to Maggie, his wife, saying, I'm going to my mother's to check on her. He's a lawyer. He knows they're going to have the cell phone. he freely admits he was there at 9:06 because he's left a text message. He's left written verification, and there's also GPS tracking. The Cellbrite that SLED has already testified. They're going to have all that. But what he said in there was, at the time I left, my wife and son were alive. I discovered their death after I came back. So I don't think there's any dispute. He was there at 9:44 because his phone shows he was leaving. Plus, they can go into the car. They know when that phone synced to the car. I haven't heard any testimony, but they can go into the car if it's a late model car and tell what time it was started and get GPS locations, quite possibly. But I don't think that's going to be of significance after the defense finishes with this because of a couple of things. Number one, I don't think there's any dispute. He was there at 9:44. 8:44, excuse me. I think it's going to bolster to a certain extent. That was a normal conversation. It was a conversation between Alec and his wife as to whether the dog killed a chicken or a guinea. There was no showing of any animosity. There was no showing of argument or hostility. It was a normal family conversation. Combine that with the SLED analysis, which shows that their phones were not moving at the same time. And Dick Harpootlian made a statement in his opening that Alec would have to be Houdini because the evidence of the phone show that when his phone was linked up with his car, it was at roughly the same time her phone was being dumped, quite possibly a half a mile away. He cannot be in two locations at the same time. I think the defense will make a lot of points off of that, even though the state has made an initial inference there.
You know Dick Harpootlian. Describe him to the audience.
He is a very seasoned attorney. He is well known throughout this state. He's not just known by the attorneys. I think he was head of the Democratic Party in South Carolina at one time. So he's known among the general public. He has a reputation of, number one, handling high-end cases, high profile and wealthy clients. He has a whole staff that is going to be research. If Dick, I don't know if you saw, but one of the briefs he turned in was 62 pages. They're proofread many times. They're backed up. They're very, very thorough. And I think he is a very savage trial lawyer. One of the things he wanted this case tried down in the home county of his client. I think he perceived that to be an advantage. And if you watch the opening, the Attorney General's office came off dramatic, demonstrative, and Dick kind of was like he was patting him on the back going, this is what happened. He took a bold step in opening. He didn't say, he didn't emphasize burden of proof and his client didn't have to prove anything. He got his client to stand up for 2 or 3 minutes. I didn't time it, but he had him standing up so that the jury would humanize him. They saw him. They feel his presence. And he looked at him and said, he is innocent. That's a bold move. And I've seen it many times. I've done it in closings where I have my client stand up and go, ladies and gentlemen of the jury, you're going to have to come back and say, Jim Smith or whoever it may be is a liar, a thief, a murderer who blew his child's brains out. And my client will be looking that jury dead in the eye. It can be very, very effective. So I think one other small thing, he has not made a lot of objections. The state will play a tape, stop it, and then ask them to repeat it. It's been asked and answered. The jury just heard it. Dick is not objecting because what he is doing is he's sitting back and he's hoping that what the prosecution is doing is putting the jury to sleep. They're not going to be listening at the important times. I think it is a little bit of a risky move, but it could potentially turn out to be a very savvy move.
This question, Grant, we'll toss it to you from Marie P. I've heard it mentioned before that it's not so much about proving that Murdaugh is guilty, but rather proving it couldn't have been anyone else. Is this true? If so, how does it fit in this case?
Well, I mean, the standard is beyond any reasonable doubt. So it's not that they've got to prove that it couldn't have been anybody else. They've got to prove beyond any reasonable doubt that it was him. And reasonable doubt, what's the best way to phrase it? If a normal person, a reasonable person would hesitate to act and immediately say guilty, then the jury must find him not guilty. Oh. So, I mean, having observed trials in my 15 years of practice, very rarely do you see somebody come into court and say, without question, it was him from the defense or the prosecution. The prosecution is trying to prove their case. The defense is arguing the case has not been proven. And in this, in the Murdaugh case, it's all circumstantial. There is no direct evidence. There's no fingerprints, no smoking gun. Arguably, there's no murder weapon clearly identified at all that's, in the hands of SLED to present. So I don't know that they're going to try to say it couldn't have been anybody but him. I think if the AG's office is on the ball with this, they may lead into, look, even if you buy into the two-shooter theory or something like that, he was involved. He's got a hand in this.
If I can chime in, I disagree with Grant a little bit. I'm older. That doesn't mean I'm right, but I have a different perspective. This is a very unique case. A father allegedly, literally executed his child. If you believe that juries don't go back in the jury deliberation room and contemplate other possibilities, you're wrong. They will. And the problem with that is this. Because of Alex Murdaugh's financial situation, it may turn into a positive back in the jury room, because if Alex Murdaugh was in fact in financial trouble, he may have accepted a case that he probably shouldn't have accepted, took a lot of money and made promises he couldn't live up to. And as a result, somebody came to execute that family, because this was an execution. And it has all the markings of the cartel. They send a message, they will blow your brains out. And Maggie in particular, somebody put their foot on her back legs and put 2 bullets in her head. They didn't try to kill them. They sent a message. And I think that the jury is going to discuss other possibilities. And with the financial stuff coming in, that may elicit a conversation of this could have been a hit on the family because of something that Alex did that he shouldn't have done, and that he was, to a certain extent, lucky he left right before the hitmen got there. The other thing, there were 2 guns. It's very unusual that 2 people would be killed in the same proximity at approximately the same time with 2 totally different weapons. That's highly unusual. That would indicate 2 shooters. And the defense has already hinted at that. I mean, they cannot bring up this crime was committed by another person. There is a statute in South Carolina that kind of limits that, but they're going to run all around it, and they're going to have the jury discussing it, I think, without any doubt. That's very, very important.
And since we are live and the trial is going on, just to update everyone, the jury is now excused until after lunch so that the CFO, the chief financial officer of Murdaugh's former law firm, her name is Jean Seckinger, can testify. Seckinger oversaw finances at the firm. Specifically, she balances and reconciles accounts, provides financial statements, files taxes, and handles government census surveys and HR duties. Judge Newman to rule on this motive evidence in the Alex Murdaugh trial. So we'll see if all these financial crimes come into play. Over here, LK has a question. How is the representation by Alex's defense attorneys not a conflict after they represented Paul? Grant, can you address that?
So the very simple answer to that is this isn't a conflict because, number one, nobody has raised the conflict issue. All right, arguably nobody would have standing to. But number two, this is the state of South Carolina versus Alex Murdaugh. It is not Paul Murdaugh or Maggie Murdaugh versus Alex Murdaugh. So they're not going against one another, which would, in essence, be no conflict.
So let's dig into some of the particulars from Wednesday's testimony. Maggie's iPhone records show that her husband of 28 years, Alex Murdaugh, made a series of calls and texts to her in the frantic minutes after her death. Alec Kim calls Maggie 3 times between 9:04 and 9:06 p.m., and then twice more at 9:45 and 10:03. And keeping in mind, again, that the coroner puts the time of death during this period between 9:06 and 9:30. I know this gets confusing. And prosecutors basically suggested, in so many words, that there was an effort to manufacture an alibi. And then Paul's and Maggie's phones lock up. They even go to suggest, the state does, that he was holding the phones, his wife's phone at the murder scene. And then the defense came back out and said that the steps recorded on Alex's phones, they recorded steps walking, didn't match up as would be expected if they were both being held, meaning the cell phones, by Alex Murdaugh. But how critical is this forensic, technology, the cell phone data, in terms of persuading the jury one way or another? Because if you buy the fact, as the state says, that he was killed at 8:50 and he's now texting, does that imply that he is in fact trying to create an alibi? And is that a big problem for the defense?
I think that, number one, there's a very good argument he was trying to create an alibi. However, the rest of that technical talk on the phone show that Alex was taking many, many steps at the time that his wife's phone was being disposed, and they know where those steps were taken. Additionally, in regard to the phone itself, there's already been testimony that cell phone coverage in that particular area is very spotty. That cell phone may work great here, but 10 feet away, it may not. And I fully anticipate that the defense is going to have an expert. There has been some allusion to a former FBI agent, but I'm reasonably confident the defense is going to have a cell phone expert who is going to get up and basically have a different interpretation, because they're not as accurate as people perceive them to be. They are subject to interpretation, and that expert's going to paint a totally different picture. I'm not sure, without being able to take notes, with the jury can't, that they're going to be able to sort all this out. And, people on the side will go, he's guilty, because they've heard shreds of evidence. I've found in 44 years of practicing law, juries take their oath very seriously. They understand that that someone was killed here, 2 people. They also understand this man's life is at risk in this trial. They're going to follow the law. They will listen very closely when the judge reads the law. And I've had jurors come out a million times going, you know what, I never thought there was that much to it. We're not out on the sidewalk. We're not sitting in the den going, what do you think or what do you believe? The jury will take the law very seriously and understand what the burden of proof is, and beyond a reasonable doubt. I think that's very significant. And I don't think that cell phone coverage is ultimately going to be a determining factor once the defense expert testifies, assuming they have one.
Kim, let me ask you a question. So, I've seen this comment so many times. Hey, I just tuned into the Alex Murdaugh trial. Man, that guy gives me the creeps. Weird vibe, To what extent, jurors are humans. To what extent I know they are, they're guided very strictly by the Judge Newman in this case, but to what extent do juries act on emotion versus the evidence presented to them? I know they're supposed to look at the evidence solely, but they've got to have, there's an emotional component too, correct?
In my experience, I've found you can persuade jurors to accept a different point of view, but it's incredibly hard to get jurors to go against their gut. That's one of the reasons they wanted this case in the hometown. This family has been there for generations. They're very powerful. They're very wealthy. They present as the ideal American family. That portrait has been painted. And the way a defendant looks, the way he dresses, his mannerisms. There's 12 people on that jury. Somebody's going to notice that. It's going to be important to some people. And I watched Alex yesterday, and what I read, and I'm not a body language expert, but his jaw was moving constantly, whether he was chewing gum or chewing a mint. It told me he was paying very close attention to what was being said. But to a juror, that could mean he's getting nervous and scared because he knows he's guilty. Emotion, I mean, what I said at the beginning, this is technology versus psychology. That is a factor. But with 12 people, there's going to be a different point of view. Some people are going to rely heavily on the technology. Other people are going to say he couldn't have done it. Did you listen to the guy who thought that was his surrogate father, his second father? A man couldn't do this to his son. The emotions are very much going to be a part of the jury deliberations.
And I'd like to get both your take. This is actually the title of our thumbnail today, this next part. This is sort of the headline grabber of Wednesday's testimony. But Grant, to you first, a text at 9:08 p.m., which would have been, according to the coroner and the state, the time of the murders, is sent from Alex to Maggie. It was never read. They can tell that by looking at Maggie's phone. And then at 9:47, which would have been after the murders, Alex texts her saying, "Call me, babe. Call me, babe." If you believe, as a juror, Grant, that the timeline is correct, and if you believe that Alex Murdaugh committed these crimes, this is a horrific text to read because it appears that he'd be creating an alibi, trying to show that, he believed his wife was still alive. What does the defense have to do here?
So let me make sure I get the question. Basically, what would be the defense approach to countering that?
Yes, correct.
All right. So if I'm sitting on the jury, I'm certainly going to look into my personal life and how my text messaging with my wife works. She's busy with our two kids. Sometimes I call and she doesn't answer. And if I don't hear back in 15, 20 minutes, I'll shoot her a text and say, call me when you get a chance. Because she may be at ballet, she may be at t-ball, she may be at swim team, I don't know. But if I was sitting in the jury box in Colleton County, based on what's coming out, in the back of my mind, I couldn't help but sit there and go, it's awfully convenient, isn't it? It certainly raises an eyebrow. Although I'm going to tell you, as an attorney, something being awfully convenient in my mind is not enough to say beyond any reasonable doubt. But these jurors, I don't think we've heard an indication of the makeup of the jury yet. I know it's been closely guarded. But in a criminal case, it's incredibly doubtful there are any attorneys or anybody involved in law enforcement on the jury. And to the layperson without any legal experience, you're going to heavily relate to your own personal experiences and look to how your interactions via phone call and text message go with your family. If I was sitting on the jury, I would also want to see from the defense more about Alec and Maggie's standard communication via text and phone call. How often do they call and text one another? What's the substance of those messages and phone calls look like? Does it fall in line with what occurred, on that particular evening?
Kim, same to you. At 9:47, Alex texts Maggie saying, "Call me, babe." Is it damning and a great piece of evidence for the state, or is it much ado about nothing?
From my perspective, what I think the defense is going to say is, ladies and gentlemen, this is normal communication between a husband and wife. They're going to tie it into earlier conversations when she was at the doctor's office. That was a perfectly normal conversation. She even expressed to a third party that she was worried about Alex because his father was terminally ill, and that Alec, her husband, the defendant, had not been getting enough sleep. He was working too much. It would show a loving and caring family. They're going to tie that back in. And again, I've got to agree with Grant. I relate my personal experiences. I have a habit. every single time I get in my car, I call my wife and tell her I'm on the way home. There's a reason, particularly for attorneys. I may be in court and supposed to be there 15 minutes, but I may be number 43, which means I'm only going to be there 15 minutes, but I may have to wait 2 or 3 hours to get there. My wife knows I don't live on any kind of schedule. Court is over when it's over. Court may start at 8:30, but it doesn't start till the judge says it's 8:30, and that might be 11:30 when the judge gets there. So my wife complained for a million years when she was at home raising 4 children. I would call her and tell her I'm on the way home. And an hour and a half later, I got there. I ran into something. A judge called. A client came in. They had money, whatever it may be. Now, my method of communication with my wife is I'm not a texter. Part of that is my generation. But I do text with clients. And when I'm several miles away, I pick up the phone and go, on my way home, do you have dinner ready? It's a perfectly innocent, normal thing, especially in light of the fact, and I have a lake house. We've had trouble with cell phone coverage. I would call my wife, and my first thought was, well, maybe she's putting the kids to bed. Maybe she's busy. Maybe she's down swimming or feeding the dogs or locking up equipment on a farm. But she could also be in an area where she's not even getting coverage. She didn't get my message. So for me to call her back again to say, call me back, is to let her know what the schedule is. Sometimes it's as innocent as, do I need to stop, pick something up, or do you have dinner ready, and what are we having? This is what I think, or I perceive, that loving, caring, and normal families do. We communicate. There's nothing wrong with that. And the state is trying to pervert that and make it look like something evil and lascivious, just like all this other stuff. It's not suspicious if you put it in context. That's what they're going to argue.
Let me kind of give you a real-time example briefly, if I may. So we've been live, according to the counter, 46 minutes.
Yeah.
Joel, as you know, we've had some technical difficulties. And what you and the audience can't see, but my dad and I can see, is my wife has been texting me this whole time, and I get the little alert. She has no idea that we're on a cell phone connection. If something happened to me in the next 5 minutes, it doesn't mean anything nefarious happened having to do with my wife. It just means she was unable to reach me. She continues to text me, having no idea what's going on in this room right now. Now, she's also watching us live. But, she didn't know we're on a cell phone connection. So, again, you take your personal experience into the jury box with you. She's got no clue. And, if something happened to me, a prosecutor may say, well, ma'am, you were texting him trying to build an alibi, when nothing could be further from the truth. So it really is. We've had this discussion multiple times, going back to, did he say I did him wrong or they did him wrong? The jury is going to hear and believe what they want to hear and believe, and nothing's going to change that.
Marie P. writes, this case is showing us just how much our phones really know, and that is very true. They know a lot. Gorgeous Junk writes, I'm sure his law license has been suspended or revoked. He is disbarred. If he is found not guilty, will he get the opportunity to have it reinstated? Do you know the answer to that, Grant?
Well, so
he's facing a million other charges.
Yeah, I'll give you the legal answer and the practical answer. The legal answer is, if he's found not guilty of this and a multitude of other charges, he could certainly petition the Supreme Court for reinstatement. The real world answer, the practical application answer is, you could knock me over with a feather if he petitioned the Supreme Court of South Carolina was reinstated. There's been very little argument that this guy engaged in severe financial fraud. As an attorney, you're in a position of trust. You're a fiduciary for your clients and their assets on occasion. And when you are arguably guilty of a crime of moral turpitude or fraud or malfeasance or whatever you want to call it in this instance, no way is the Supreme Court of South Carolina ever going to reinstate his law license. I think that's
I don't think there's any question.
No way.
As part of our license, it's not that we have to avoid impropriety, which we have to do, obviously, but we're even held to a higher standard. We have to avoid even the appearance of impropriety. This is a lot more than appearance. You've got to also look at Alex is not a poor man. Alex is in his 50s. Even if he got his law license back, I think he realized nobody would come to him. No law firm's going to have him. And I don't see him doing it. And I don't see the Supreme Court ever giving him back his license. I don't think that's a possibility.
So this next question, Grant, I'll toss it to you from Plato. This has come up a lot. I get tweeted about this all the time, and maybe you can set it straight for the record. What do you mean the jury can't take notes? Is the jury allowed to take notes and they just have to leave notebooks with Judge Newman before they leave for the day, or are they not allowed to take notes at all? Do we know?
All right. So at the start of the trial, occasionally in a complex litigation case, you will see either the foreman of the jury ask, "Can we take notes?" And or not, and the judge will address it. I have not seen to this point the jury foreman ask in any of the notes from the jury. I may have missed it, but I haven't seen it. "Judge, can we take notes or keep notes?" And as I've been watching the reports and speaking with Fox Carolina, with their reporter in the courtroom, it's my understanding Judge Newman has not allowed the jury to take notes, and nobody's seen any notebooks, notebook paper, pens, pencils, anything like that in the jury box, to my knowledge. So it's my understanding the jury is not being allowed to take notes. At the end of the case, when the evidence goes back, they'll have to sort and sift through all that, and it's highly likely at that point they'll be provided with a notepad and a pen to, sort of sketch their thoughts at that time once it's sent back for deliberations. But to this point, I haven't heard anybody comment that the jury is being allowed to take any form of notes.
I agree. I've heard comments that the judge would not, or it hadn't been addressed. But my experience is most of the time, and it's up to the judge, judges do not want jurors taking notes. The reason being is if a jury said, "Well, I wrote it down," that's going to have that juror's voice carry more weight than someone else's. It sounds more accurate or authoritative. They may have written it down wrong. Judges want each individual juror to have an equal vote. Now, in a highly complex case with lots of numbers, and this one has had tons of time. I mean, you've heard repeatedly 8:44 and 38 seconds and 8:37 and 30, and the prosecution and the defense have gotten up with their magic markers. If the jury had wanted to take notes, I think there is a serious possibility Judge Newman would have allowed it, because this is a long, complex, and the prosecution is making a big deal over the precise timing. There's a lot to this case, but I don't think the judge is going to let one juror take notes. He's going to let them all take notes. And at this stage, I think that tree has already been cut. They're not taking notes, according to my understanding of all the reports, which I find to be a little unusual and to be honest with you, a little bit scary that they're not allowed to write this down and memorialize it as it occurs.
I'll tell you what, I would have a super hard time remembering things I get confused just on the day of stuff. But speaking of that, some of the particulars, again, from Wednesday's testimony, a SLED agent, Britt Dove, was called about Maggie's cell phone data. And then the prosecutor asked if calls were deleted from Alex Murdaugh's phone. And the SLED agent says it appears that way. So we're talking about some deleted information. What that means is up for the jury to decide. Something that struck me, again, I'm a former broadcast news guy, told stories for a living. So I have a tendency to, to gravitate to the emotional. A young woman named Megan texted Paul around 8:30 the night of the killings. They started to discuss movies. She asks Paul for a recommendation and says she doesn't want to watch a sad movie. Quote, "No, I need something happy." That really kind of broke my heart, knowing what would happen just moments later. I wonder, Kim, how do you think testimony like that affects a jury? It really humanizes Paul, right? Whether you think the father killed him or not, here's a young guy talking to a young woman at the beginning of their lives, talking about watching a happy movie, and now is, not to be so explicit, but his brains are literally blown out of his head. How does that play to a jury?
Well, I think literally from opening statements, It was very graphically described. I don't think any human being with a heart whatsoever could listen to that and not have just a tremendous outpouring of emotions and sympathy. This was a young man who hadn't even really started his life, and literally his brains were blown out of his head. It impacts you. It hits you. It makes you realize the seriousness, the finality of the whole thing. There's been many contexts, and they leave on a note. That text was never returned. That phone was never used, and they kind of lower their voice. It's the final impact. And he was going about a normal day, quite obviously, in his Snapchat thing. He was showing pictures of a dog's tail wagging and was concerned with a dog being healthy, talking to his best buddy. And he has this young girl. They're talking about movies and happy movies. This was not just a day in the life. It was the last day in his life. And in his mother's life, on top of that, that impacts people. It makes it's going to make that jury take this very, very seriously in two different directions. One being, this is a very serious case. Enough has happened to Alex Murdaugh. He's lost his wife and child, maybe because of something he did that was stupid or something he got himself into. If you think there's a possibility he might be innocent. But if you believe that he is guilty and proven beyond a reasonable doubt, it's going to make you put the hammer down on him without even thinking twice. I'll vote guilty and have no reservations, no second guessing. I'll never underestimate the impact of the emotions of the juror and the witnesses and even the lawyers, for that matter, because this is real life. This is not a movie. It's not a happy movie. This is what actually happened to people's best friend, their son, their best buddy, their confidant. It hurts. And juries I'm sure there are plenty of jurors who have cried throughout this thing over many instances. No one wants to hear those brutal details, but you have to.
And Grant, I can tell you had a great teacher, because I know when Kim speaks to that jury in that jury box, you can bet he is having an impact on him. He's a great speaker. Lisa Orphan, we're going to go a couple more minutes, because if these gentlemen were charging me by their billable hours, I'd be broke. So I got to cut them away in a few minutes. Lisa Orphan writes, financially, he is drowning. And I'll send this to you, Grant. He was a drug user. Maggie wasn't playing when she wouldn't put her property as collateral. Motive, Maggie may not have known how bad the finances really were. What do you make of this comment that she was in the dark about it?
Well, so first and foremost, I don't think anybody really knows what his true financial position was. This is a guy who hasn't exactly denied that he was engaged in serious financial crimes. Oh, now he made a whole lot of missteps. You know, he opened a DBA account. I think it was Alex Murdaugh, DBA Ford, she was depositing money into. I think the testimony is going to indicate it was somewhere around $10 million he took that didn't belong to him. I don't recall off the top of my head how much money they owed on any of their real estate, but I know that I think Moselle itself is under contract to sell for $3.9 million. That deal is currently frozen pending resolution of some of the civil case issues. But I don't think anybody knows except Alex Murdaugh what his finances truly are. It wouldn't surprise me if there are other bank accounts that have not been discovered, if there's money squirreled away here, there, and everywhere. I would personally find it hard to believe that Maggie had no clue what was really going on. They were both certainly spending money. I mean, even on the last day there was some testimony. It wasn't a Gucci purse was bought for, what some people consider to be an extraordinary amount of money to spend on a purse. And I personally know people that would fly to New York City first class to buy that purse and then fly back and not bat an eye. So I don't think we really have a grasp, or may ever have a grasp, on what the finance, position of the Murdaughs truly was. Is it going to call into question motive that maybe Maggie found out how bad it really was and perhaps that's motive? Absolutely. I think you're going to see the Attorney General's office and Creighton Waters push that theory. You can certainly see from what little bit I watched this morning, they are full tilt gung-ho about this is a financial issue. They were killed to divert attention from the financial crimes. They were in dire straits. And he had to take action, but that would be contrary to what they were apparently putting in motion back in 2016. The way that they structured it in 2016, I don't think any of Maggie's property would have truly been in serious jeopardy. It had gone past the 3-year mark, and it's going to be terribly hard to claw that back. Let's assume for a second, hypothetically, she did consult with a divorce attorney and was planning on divorcing him. Kim and I both do divorce. If we were representing Alex Murdaugh in that case, we'd say, well, Judge, it's marital property. It needs to be split 50-50. That's assuming he comes clean from the financial crimes. If we were representing Maggie, the first thing we're going to say is, well, now hold on. This appears to be a post-nuptial agreement in which he assigned all the assets to her. We're not dividing it. So I think Maggie would have been in a great position to hold on to everything that had been signed over to her in 2016. So is it a motive? I think it's definitely going to be presented as a motive. Does it have any real teeth? Not if Dick Harpootlian and Jim Griffin really bring it home.
Listen, if you think for a moment that lawyers, particularly successful lawyers, don't have egos, you're strongly mistaken. This man comes from generational wealth. His great-grandfather, his grandfather, and his father, they own that town. These people have lived an extravagant lifestyle. Do you believe for a moment that Alec would come in and confess to his wife, I've messed up, I made bad business deals, we're broke? Absolutely not. He's not going to let down the legacy. Would his wife question where the money comes from? No, this is part of our legacy. It's an entitlement belief. They lived, she was hanging out at the Edisto Beach House. They had a plane there. They had more heavy equipment, more cars than anybody could keep with. They have 1,700 acres. They were living the life. And most people are so busy living it, they don't question it. And Alex wouldn't have told her the truth. And we don't know. There may be millions hidden in foreign bank accounts that you're never going to find. Or he may be broke. Nobody knows, and he's not going to. His pride and ego and possibly narcissism, it would never allow him to admit to his wife that he was a failure.
Interesting take, and I would tend to agree with that. One last bit of testimony on Wednesday, which I think is possibly the most important. Rogan Gibson, who's Paul Murdaugh's childhood friend and considered the Murdaughs a second family, and that is a quote. The prosecution towards the end asks Gibson, when he was on the stand, if he hears his second family on the call. Gibson says he's 100% sure he heard Alec and Maggie's voice in the background of a phone call that night. He tells the prosecution that Paul and Maggie sounded normal on the phone. Grant, how critical is that testimony in your opinion?
I'm going to tell you. So I got to watch that testimony, and I do not think that did for the prosecution what they thought it was going to do. Oh, that testimony from where I sat was critical for the defense. It substantially humanized Alex Murdaugh as he sat there. It really brought home the Norman Rockwell painting of the all-American family. These people welcomed me in. They treated me like one of their own. They let me use their equipment. They let me hunt their farm. This guy was a second dad to me. Paul was a brother to me. Maggie was a second mother to me. It really humanized the entire situation, in particular Alec, because he kept looking at Alec. And Alec was, responding. There was body movement. There were tears. There was jaw. There was a lot of response by Alec to Brogan's testimony. Oh, and I think that the prosecution really thought it was going to be this dynamite moment of, aha, we've now confirmed It's Alec. It's his voice. And all it really served to do was, well, yeah, that's his voice. He was there, but I don't think there's any denying he was there. And I was really interested with the follow-up witness. I think his name was Will. Did you catch the last question that Creighton Waters asked Will yesterday? Do you really know, or maybe it was Brogan, do you really know Alex Murdaugh? And I don't think that was the answer Creighton Waters expected to get. Yes, I know him. And it was over the defense's objection. Judge Newman overruled and let it in anyway. But was it critical? Brogan's entire testimony was critical. I just don't think it went the way the AG's office thought it would. I really think it landed in the defense's lap, whether it was by design or pure luck.
And Kim, that's lawyering 101. Don't ask a question where you don't know what the answer is going to be, correct?
First thing I said when I heard it, because that was telling a joke that nobody in the room got. When he asked that question, I naturally anticipated the kid was going to say, or the young man was going to say, I thought I knew him, but after all this, no. But that's not the answer he got. He reaffirmed, I know this man, even after all of this. It was not the expected answer.
Wow. So Don Hagerman writes, I think if the financial fraud are brought in, his goose is cooked. It's like a cheating spouse in a murder case. It weighs, and time will tell. I want to thank both of these gentlemen immensely. We struggled to make it happen, but we finally did. Grant Varner was born and raised in Greenville. He practices in multiple areas, including divorce, child custody, child support, personal injury, and you can tell by hearing him just now, he knows his stuff. Grant, your final thoughts, and you want to go on the record if this is a hung jury, an acquittal, or a conviction? Any desire to let us know your thoughts about that?
Let me tell you, the smart money is on hung jury. With the revelation this morning that Judge Newman is likely going to let a whole pile of evidence on, and there's a strong potential this case could continue on conservatively, an additional 2 weeks past Friday the 10th. I'm going to reserve opinion until I see all the evidence. This thing has taken more twists and turns than I think could have ever been anticipated.
Like Joel, I want to thank you for the opportunity of letting us have this audience. And I'll go on a limb because I'm older. I don't have as much to lose. And my opinion's just as good as anyone else's. It's a hung jury, especially with the financial stuff, because the defense is going to use it to say the reason they tried this is because they don't have the evidence on the murder case. So I stick by hung jury, and I have a right to be wrong.
And if the jury is hung, will they retry Alex Murdaugh at another date?
Oh, I think there's going to be so much pressure on them. They're going to feel compelled, but they will find out what the jury vote is, not what each person vote, but the total. And if it was 11-1 for not guilty, that's really going to, why would you waste the money again when you barely got 1 out of 12? If it's 6-6, I'd almost guarantee they're going to retry it. And if it was 11-1 for guilty, no question they'll retry it. They'll wait, analyze, and see what they have. No lawyer wants to try the same case twice, but it'll be a different trial if it's retried. And I mean, don't forget about the fact if he is convicted, this is not going to end. There will be appeals, and there have been some really close calls here. There's a lot of issues left open for appeal.
And that, my friends, is one of the best criminal defense attorneys in the state of South Carolina, Kim R. Varner, who has been practicing since 1979, and he's appeared on every media outlet you can think of. Gentlemen, I hope sincerely that you will come back. A quick programming note. We will be back tomorrow with another episode about the Alex Murdaugh trial. And Fridays is Get Your True Crime with Phil and Gil, your True Crime Phil. So stay tuned to that. Love you, America. Till next time.